Happy to do so.
Okay, so welcome back, everybody. 2:15 in the afternoon, your time. Fascinating morning's presentations. Thank you to all the presenters. Delighted to welcome Todd Lochner back. Todd came and spoke last year in person. I was just saying, if you didn't hear me, I found his talk last year absolutely riveting. I mean, it was just so relevant and on the money. So I'm sure it'll be the same again this year, Todd. So without further ado, I'm going to hand over to you. Thank you.
Good morning, everyone, or afternoon, as the case may be. For those of you who will recall seeing me last year or who have seen me in other speeches, you know that I usually like to be very interactive, and that's frankly somewhat difficult with Zoom these days, particularly given that we can't have the back and forth. One of the things that I often do, however, is find out who my audience really is and the kind of work they're doing so that I can tailor what I'm discussing. So if I could just take a brief moment, and if you guys could please just put in the chat really quickly, are you primarily doing recreational vessels? Are you doing cargo work? Are you in the brown water sector, the blue water sector of the shipping side for survey work? Just a one word or two statement in the chat so that I can see really quick sort of where we are as a whole in the room. And if you do 25 things like many of you do, just put your most prevalent items. Great, I'm seeing a few things come through now. And while you're doing that, I will tell you a little something about myself. As you can see from the gray hair, I've been doing this for a little while, 22-ish or so years. I've been practicing maritime law, and I've been giving speeches like this for about that same period of time. I have a practice here in Annapolis, and I have both some blue water work, but primarily it is the recreational based. As you can see, my branding there on the splash page is boatinglaw.com. And that was a conscious effort to do some branding. But I have had some blue water work, arrested several ships, some injury issues on a couple of ships all over the world, actually. I'm involved with a death case out of Panama right now on one of the world's newest LNGs. But in any event, that's my quick background. So I've got the gray hair to show some of it. Oh, as I click through here, there we go. Oh, I forgot to mention, I'm also the chair. I used to be the vice chair. I'm now the chair of the Maritime Law Association's Recreational Boating Committee. So as you have questions that come up or want to do some interface with the attorneys doing this work throughout the country, feel free to connect with me. I'm scrolling now through the chats and the responses that you've given. It looks like we have some project cargo, quite a bit of pleasure yachts, a little bit of brown, mostly recreational. Okay, so to the extent, and there's some hull and machinery. All right, so we've got a pretty broad scope here. It's going to be difficult to tailor this to just one particular item by virtue of being so broad in the scope. I would ask that as you have questions popping up throughout, I think that everyone can go to their chat, and instead of clicking on everyone, click to the host, and that will send the messages to our hosts so that they can sort of triage them and give me questions that have arisen throughout the presentation. I find that is a better way to work through the questions in a Zoom format. And I will kill my chat screen now.
That's fine, Todd. I'll make sure I pick those messages up and feed them into you.
Right, at the end, I'll allow you guys to triage the questions.
Fantastic.
And then if we get through them and have time, we can do open mic, but just experience says that's a better way to go. With that said, let's move right into what are we going to be doing today. This, as you know, is my roadmap. Many of you have seen me before, and I've had professional interactions with quite a few people on this telephone call in one form or another. So you've probably seen my format. I always do the roadmap. Point one, we're going to discuss today the new vessel emission standards, what that means to you. We're also going to have some discussion about air quality on vessels. Now, this was really a deep dive earlier on the air quality. We're not doing that kind of deep dive. I'm just going to do the interplay of what you heard about earlier relative to what you might be looking at from a surveyor liability perspective. And then finally, this may seem silly, but there are so many people that don't actually test some of the equipment that they say is working just fine. It seems basic, but this is one of the areas that we're going to discuss a bit in terms of your potential liability. We jump right in now to vessel emission standards. This section is filled with acronyms because when you talk about government, you're going to have acronyms. MARPOL Annex 6 is the one we're talking about right now. I'm sure if we were live, I'd be doing raising of hands and all that sort of thing, but I'm sure most of you have heard about this. The International Convention for the Prevention of Pollution from Ships, Annex the 6. So this includes all kinds of requirements about vessel emission standards. And by the way, this went into effect this month. This is what it's all about, guys. We're doing air pollution. We're doing nitrogen oxide is the real issue here. So we're trying to lower the sulfur fuel requirements. All of the requirements are applicable here. We're talking manufacture, we're talking certification, operation of the vessels, and this is the actual engine performance as well as the fuel quality. Now you will note that this is a big swath. There's a lot to do and cover here. Even larger is that this applies to 173 countries who are signatories to MARPOL. So it's not like, you know, Paris climate accords where people come in and out every 4 years. I'm joking. We are one day after the inauguration of Joe Biden for those who watch this later. So that's why it was a timely joke. We have something where it's pretty much worldwide for all practical purposes and everybody's in it for the long haul. We are really looking at this sector here. We're looking first for an IAPP certificate. So that means International Air Pollution Prevention Certificate. All vessels, gross tonnage greater than 400 GT. So those recreational vessels and the folks that are doing that, this is not really going to be incredibly relevant, this little tiny sliver of today's talk, because you're doing a lot smaller vessels typically. However, you should still be acquainted with all of these things. So don't forget that now, starting this month, you should be looking for that IAPP certificate. The other thing that you should be looking for is the Engine International Air Pollution Prevention Certificate, or the EIAPP. That doesn't trip off the tongue as an acronym. They should requisition a new one. But that's what we're looking at, these two certs. And these are requirements for diesel engines over 130 kW. So that's what this applies to. Now, when you get to the point of perhaps we can give you a PDF of this PowerPoint deck, all of these items on the bottom that you see should be available as click-throughs so that you can actually see the individual sources and find some ways to dig deeper. Again, we're not here to dig real deep on this. This is an overview of what became effective this month that you need to know about. So in addition to MARPOL, which is the international side of things, then we go to the US regulations. This is just to tell you where to find them, really. There are multiple tiers, 1, 2, and 3, that are specified. And it does in fact apply to US flagged and foreign vessels in US waters. Now, there is a minor exception that might be available for solely coastwise vessels that would otherwise meet. Let's not get into the minutiae on that. Just know that there are US regulations that need to be attended to. The tiers are codified here, so you can find them. Google is a wonderful tool these days. As I indicated, there are different tiers, and the EPA regulates tiers 3 and 4 for the certifications of engines. So not every engine is regulated by the EPA. And note this is EPA and Coast Guard jointly working on this effort. So this is a 2-agency effort. Essentially, any engine built after 2016 that's over 130 kilowatts for output will automatically have to be Tier 3 right here, compliant. So that's the short of it. And here's where you find the certification requirements in this CFR, which all of you, I'm hopeful, know what these are. 33 USC is a United States code, and a CFR is a code of federal regulation. So you have the statute, and then you have all the details that are put forth by the administrating agencies. And in this case, that's a plural because it's both Coast Guard and EPA jointly, which is not always the case. And here we go, so another site for you. Again, this is just to show you where to get these things. With that said, now we know what it looks like. What does it mean for you? Because that's all that matters at this point in time. We're based on tonnage and flag states for the IAPP. That's the International General. So that certificate is based on tonnage and flag state. And then I forgot to ask the question early on, how many of you are working for class societies? But this is an important item for you guys. If you are working for class societies can be tasked with confirming this compliance. So once the certificate is issued, then the class society has to confirm the compliance, which is where you guys are going to come in. Because you are the arms, eyes, ears, touch, see, feel for the class society. In fact, some flag states, because outsourcing is just a great way to do things, delegate the actual issuance to the class societies. So in addition to confirming compliance, you may find yourself in a position, depending upon the flag state of the vessel and the class you're doing work for, actually issuing the certificates. Now, frankly, most of them should have already been issued, but that's not always true. There are probably quite a few that still need to be issued because, again, this is supposed to have gone into effect this month. What else does this mean for you? If you're buying a vessel privately, even if it's a yacht, and it's a large yacht, now most of them are not over 400 gross tons, but nonetheless, you want to make sure that this is something that's on the list to do. Don't forget the due diligence list. And some of you may have seen, I have a due diligence checklist for all the vessel transactions we do. This entire environmental side now has to go on that due diligence checklist. Whereas before, the environmental side was there, but not nearly as detailed on these certificate sides. So now with this new MARPOL annex in effect, you'll need to get the certified engines. And that is independent. You see the ECHO IAP versus the India APP. Even if you don't need the general certificate for the ship, you may need the certified engines under the EIAPP that we previously discussed. So when you're out there on the ships, these engines, the distinction here, the IAPP versus the EIAPP, the EIAPP are strictly kilowatt based, and there's a lot of unregistered or otherwise unregulated vessels that still need to comply. So just because it doesn't have a COI, et cetera, you still have to technically comply with some of this. Now, inspect the book of engine parameters. It will come the responsibility really of the class inspectors and all the private surveyors to start doing these inspections, certifications, and keeping track of it. So you should make sure that anything that is in a purchase scenario has a record book, and it should in fact transfer. This is one of the things, even for yachts, particularly the larger yachts, it's easier, but the smaller yachts, they grumble. I request any transfer of record books of any variety, log books included. So finally, on this point, all of those tier 3 and tier 4 engines, which again is kilowatt based, you have to have the record book of the engine parameters. Now, I have been spewing acronyms like there is no tomorrow. Couldn't resist, guys. I have found over the years of doing this that about 8 to 10 slides in, you all start to gloss over. And that is no more true than when you have those scenarios of a bunch of acronyms being thrown at you. So, moment of levity. Thank you for your indulgence. We move on to roadmap point number 2, air quality aboard the vessel. Now we start looking at some cases. 2018 case, Eastern District of Louisiana. Now, for those of you who have been around the industry for a while, you know that the Eastern District of Louisiana, and particularly Louisiana and the state courts whenever possible, are a hotbed for plaintiffs' litigation. You can't even drive through some of the parishes in Louisiana without seeing billboards for plaintiffs' attorneys trying to, seek seaman clients for litigation. We have a case that develops out of Louisiana on this air quality issue. And in that case, it was the Brownwater sector. Captain of a supply vessel was sued. He sued after collapsing on board from carbon monoxide poisoning. And this was due to the engine exhaust leaking into the living spaces aboard the vessel. Now, the court used the term house. So there was a significant indications in the quote house of the vessel that the exhaust was leaking in directly from the engine room. Clearly, this is a bit of a problem. This can make the vessel unseaworthy. Apparently, there were stains on the walls of the passageways and staterooms where this exhaust leak was occurring. And unseaworthiness, when air quality can make a vessel unseaworthy, that has a lot of implication. So we're going to take just a moment, back up slightly, and talk about this term unseaworthy. There are various reasons that the term unseaworthiness exists, and there are variations about the application depending upon its use, whether that's Jones Act or insurance, etc. The overall definition of unseaworthiness is the extent to which a vessel is reasonably fit for the intended voyage. A vessel which is reasonably fit for a Caribbean voyage may not be reasonably fit for a voyage in the North Atlantic. A vessel with a crazy, I use a technical term there, completely not politically correct, but someone who has a split personality or something like that. Gun Sapporo was the guy's name in the case, who turns around and kills one of his crewmates, can actually have created an unseaworthy vessel. There are lots of reasons and ramifications of unseaworthiness, but poor air quality may make a vessel unseaworthy. That is to say, not reasonably fit for its intended voyage. So if the air quality is polluted sufficiently, that makes the cabin and the living spaces within the vessel unusable, then it's not reasonably fit. So we don't know exactly, because once you find things like that, and cases tend to settle, which is one of the beauties of our system. But we will note that why this matters to you is you don't want to be the one who missed or failed to report issues with the air quality of this variety to either the class or the owner. This is a significant area where the surveyor, if one occurred at any point in the recent time of this case and this vessel, that's bring them in as a third-party defendant. You can also be sued directly depending upon a whole host of factors we won't get into for these purposes of air quality, but you can in fact be brought in. This is an area that you need to keep an eye out for. I might want to also add just that the court in this case also said that even temporary conditions that make the vessel unfit can render it unseaworthy. So even if it's temporary, that can be another scenario. There are other cases like this. There's another one that goes all the way back to 1990. So this isn't a new issue, but we do have a new case on the issue. that's the quick look at air quality as a summary. Now let's take a little more of a focus and go in the direction of testing equipment functionality. This is one of those things where you have to get out of your truck when you do the survey. And I know that seems, I'm preaching to the choir, because you guys are the ones and gals are the ones that actually get out of your truck. But you would be shocked to find the number of times that I'm left wondering whether the surveyor even went to the vessel. I had a scenario where a vessel was shown by a now deceased surveyor, so I could talk about the file, to be perfectly fine, no rot, good shape, etc. I went to the vessel's bulkhead. I took a number 2 pencil and I pushed the number 2 pencil through the bulkhead. The wood was that rotten that I simply pushed it right through. And you have to wonder, did the guy get out of his truck when he did that? And that's the open question. So you can't just step on the deck, do the machine gun approach of, oh, I see it all, looks pretty good to me, let's sign it and off we go. I know I'm preaching to the choir, but I've seen it too many times. Now, where are some of the things that you can actually start to look for on a more granular level? You would be surprised the number of times that standing there with your cell phone, it's so easy to go on vesselfinder.com and check the AIS. Just make sure that it's transmitting. Just make sure that it's actually has the vessel that you happen to be standing on, looking at the AIS unit, actually in the same geographic region where you are currently standing. If you turn the thing on and you can't find it on vesselfinder.com, ultimately there might be a problem. So do something simple. It's very simple. Furthermore, testing radars. This is an area that if you have an extra 10 minutes, not even 10 minutes, you can really provide some information to your clients on the performance monitoring. So you should be coming back with numbers on your report for the magnetron and the attenuation values. It's, there's a test cycle. There are plenty of YouTube videos showing you how to do it. Many of the radars will just very quickly give you those numbers. It doesn't take that long, and you should do it. And it should be in your reports. If it's not, and you have the blanket statement like, hey, everything looks fine to me and it seems to be pinging, it's rotating. I mean, what good does that do you if the performance monitoring was never done? So take the time to do those very simple things. Radio checks are obvious. Again, channel 9, the recreational channel, just take a couple, it takes a second to do it. And don't forget to double check as well on the radios, the extent to which the MMSI has been set up on recreational vessels. Remember that without sending the radio back to the manufacturer, you only get 2 times of changing the MMSI information. So whether or not that has ever happened before, whether it's been set up appropriately, what it says the MMSI information is on your VHF radio is a good thing to check, because a buyer may want to know that information sooner rather than later, particularly if they get aboard, they try to change the MMSI and they go, oh, wait a minute, I have to send this back to the manufacturer. The reality is, well, now you got to buy a new radio, which may not be that big of a deal, but take a moment. It only takes a couple clicks on the radio to find that information. So again, I'm not going to go through my slide verbatim. You guys know, in the interest of time, because I'm trying to keep enough time for questions here, but I will say that you guys know the details of working through generators and power supplies. Actually do it. Again, I see the worst of everything. I know it. I get it. But the number of times the surveyor clearly didn't get out of the truck is just mind-numbing to me. And that just keeps popping up. Probably twice a month in my practice, I see something where you have that duh moment and you wonder, what were they thinking? Because it clearly didn't do whatever they said they had done. And if you're listing something that's not actually inspected, make the note that you didn't inspect it. Again, particularly on the recreational vessels with the buyer surveys, a failure to do it is just begging for a lawsuit. And you can get that lawsuit if you don't do some of these things we just discussed, and if you don't actually start looking at the new regulations. So, big question, have surveyors ever been found negligent in this context? Fortunately, not often, but the answer is yes. Now, why maybe not so often? One of those reasons may be that, frankly, surveyors often don't have enough funds to make it worthwhile. So when we take a look at some of these things in the lawsuit context, we have the people who do have enough money to be sued are often the classification societies. So there was an ABS, American Bureau of Shipping, being sued for negligence in 2012 when they declared the vessel seaworthy. It turns out that ABS was held liable through indemnification because they miscalculated tonnage as well. In another case back in 1988, you know, they go on, but I'll just give you a couple more quick examples. Again, suing when you don't find dry rot in a catch. I have had cases that have settled that were obvious misses when you don't see the fact that you can stick a pencil through a bulkhead, for example, and say there's no rot on the vessel and all looks fine. That's a bit of a problem. The other one that you might want to note for those of you on the commercial side, in 2003, a marine surveying company itself, rather than the class society like ABS, was sued because the surveyor failed to catch, there was a faulty leg on a lift boat, which subsequently collapsed. So you want to make sure that you note that every little thing that fails that you said looks fine, you could in fact find yourself on the hook for. We'll skip past lawsuit, go right on to take a look at another file as we work through some of these things. I'm not going to read the slide to you. You guys can do that. This kind of summarizes where it is. What does undesirable mean? When you put the trim of the barge was undesirable. If the trim of the barge is not desirable because there is a massive list or the trim fore and aft is not desirable, how can you possibly state that the cargo was properly loaded, stowed, and secured for the intended voyage? Notice that intended voyage language again, because all of this ultimately, frequently, will be coming down to seaworthiness, because you may find that there's no coverage if there's no seaworthiness of the vessel at the time the policy attaches or at the time the vessel breaks ground, if it was unseaworthy. So you can see that here in the load scenario, this vessel was probably, and I don't recall in the particular case whether the vessel was ultimately found to be unseaworthy, but it was probably unseaworthy, which probably had an insurance issue involved. So you have to go to the next pocket, which is the surveyor pocket. Now, we picked on ABS. Let's pick on Bureau Veritas a little bit. This is an old one, but decent example. This problem isn't new, but the seeking of indemnity against the class society is, you know, it's a common theme, because what is the purpose of conducting the hull and tank inspections? You're the eyes and the ears, whether you're working for a class or whether you're doing a direct inspection at the behest of an owner. So you're the eyes and ears. You have to find what you find, and if you don't, you may have breached a reasonable care duty, and that's what equals negligence. Now, you can actually be negligent, but that doesn't mean you will be held liable, because you can breach your duty, but someone needs to prove the causation link between the sinking and the actual negligence. So you could be completely negligent, but if it had nothing to do with the sinking or the casualty or whatever the case may be, then you get off the hook. Keep in mind, though, that you still don't want to have to go through the litigation, because if you're not insured, it's almost automatically a bankruptcy scenario just to pay the 100, 200,000 or whatever it turns out to be to the lawyers for defending the case. So that's almost all automatic bankruptcy unless you're Bureau Veritas and there's coverage in the first place for this sort of professional negligence. This case is interesting because the presumption of unseaworthiness cannot be used against the class society. So this is this is good for you guys. You don't want to have legal presumptions going against you, because whenever you have a legal presumption going against you, you are left in the position as defendant of having a burden of proof. And you don't ever want the plaintiff's burden of proof to shift to you as the defendant because of a presumption that's required under the law. Now, the seaworthiness thing is a non-delegable duty. So that duty is not something that the owner can just say, hey, not my fault. He has to do something about it. That doesn't mean that contractually or otherwise there may not be some liability if the vessel is found to be unseaworthy. But seaworthiness itself isn't something that can be 100% delegated to a third party. And again, this is a touchy topic because seaworthiness has different uses in different contexts. As one context in the Jones Act scenario, there's a different context when it comes to insurance cover, breaking ground at the initiation of the policy, etc. Captain Obvious for the last point, which is the one I just made. And what are a couple of other cases that you might want to know about in the big picture context as you keep doing what you're doing? This dry rot thing, as we said, you have to actually catch the obvious stuff, or in that context, the buyer is in fact going to get you. This is a recreational case I discussed briefly earlier, and the standard of care here is the exercise of ordinary care and caution in the exercise of your profession, to take the language from the case itself. Now, we banged on Bureau Veritas. Let's bang on ABS one more time here. As I described earlier, you missed the tonnage altogether. I mean, come on, that's kind of a big deal to get the tonnage wrong. Now, having said that, I didn't do a raise of hands virtually on how many ad measurers we have in here. I suspect we don't have many, if any, ad measurers, which is its own separate profession in this room. But that is exactly what happened with ABS, as they got caught getting the ad measurement wrong. So with no further ado, I'm not going to belabor all of this, and we're at the 33-minute mark. So it's time to do something completely different. And again, this is my 8 to 10 slides later. Somebody has to wake up because your eyes are glossing over with all of this legal gibbery. Hopefully you're awake again. Now we move on to this question, which we covered a little bit last year, but most of the people in this particular seminar were not in attendance last year. For those who are, I apologize. But this is an important point that just keeps coming back, and I really think it's worth reiterating. To whom do you owe a duty? There are a whole group of people on this slide that you owe a duty to, potentially. Some of them are obvious, the customer, right? The class society. And as we said, particularly in this emission context that just went into effect via MARPOL, the government entity maybe. And then, of course, there's the future passengers, which is an interesting but tricky question. So class societies hire you as an independent contractor, or the flag state hires you for their alternative compliance programs. Those are all possibilities. The tricky one now, what about the future passengers on the vessel? If their injury is foreseeable at the point at which you do that investigation, then it is possible that they might bring the claim against you. Foreseeability is the legal question here. So what's your duty? That thing duty, that amorphous concept that has been oft litigated for centuries. Literally centuries now that we are in 2020, 2021, thank God. So what do you do as a reasonable person in this situation? This reasonable person, this amorphous context of what is a reasonable person. I will tell you that no lawyer is a reasonable person. After you go to law school, you cease being a reasonable person. But where do you find what a reasonable person would do? Well, first, a reasonable person would not allow what happens often is the client impacting findings. Lawyers will often speak privately behind surveyors' back. And I have on many occasions heard that guy's a whore. And the response is something to the effect of, yeah, but he's my whore this time. So don't get that reputation. Don't let the fact that a particular insurance carrier gives you 80% of their business affect your ability to actually open your eyes and put what you see in a report as opposed to what you want your client to hear because they've asked you to hear it. I know I'm preaching to the choir because the people attending are not the ones that are doing this sort of thing on a regular basis. I see so much of this horrific bit in what I do. It's just mind-numbing sometimes. So don't let the organization give you its directive, your client. Obvious, don't rush, don't skip. We did kind of cover that ad nauseum earlier. Changing findings. I had one deposition that was just beautiful. I had a surveyor who was brought in as the end-all be-all expert on this recreational vessel. And through discovery, I ended up coming across the back and forth between the ultimate client on the other side, not the lawyer, but the ultimate client opposite us, and this surveyor. The report, I got a red line of every single change throughout the report and the 5 or 6 different versions of the report. The surveyor's final report parroted exactly what the lay person, boat owner, litigant wanted him to say. He cut and pasted from the email into the report, word for word. Don't be that person. It gets you nowhere. And I've also seen, I have a current case now where I deposed the end-all be-all expert according to the other side. And my expert and I had gone through all that we needed to do. We put some maneuvering boards out and we did our plots. So the time came for the deposition and the opposing expert. And I said, well, here's a mow board. Why don't you plot it based upon this information you just told me that you used the lat longs? He couldn't plot on the mow board at all. Impossible. Just couldn't even figure it out remotely. And ultimately, the whole issue is where were each vessel in the collision relative to one another at different points in time, which the mow board shows you precisely. So don't take the job if you don't know how to do the work. And this guy had the job for a year and he never bothered to learn how to do plotting on the mow board that he probably knew at one time 30, 40 years ago, but had long ago forgotten. Do care that you are held to the standard of good marine surveying practices. So what's customary and used in the practice? You don't want to be in a position where you're arguing I screwed up because everybody screwed up. That doesn't sound very good to anybody. That is not a good argument that you want to be making from a stand in front of, 6 jurors with alternates in a civil litigation context. I'm not a problem here because everybody does the same screw up. Don't take that as your defense. Let's move on a little bit. Whoops, my button failed to work. There we go. So what else? Duties to clients. It is possible beyond this negligence thing we've been talking about. Remember, negligence is duty, breach, causation, that proximate cause thing, and damages. So you can breach the duty, not have the causation, you cannot have the damages, but if you have all 4 elements, then you're negligent. Beyond negligence, you may have a fiduciary duty. Now, a fiduciary duty is a different beast altogether. You may have contract privity. So with the actual person that hired you, there's a contract claim. And then you may have this other thing called warranty of workmanlike performance, which is implied in maritime law. So here you go. Here's your definition of a fiduciary duty. Take a minute, read the slide. I'm not going to do it for you. Just read it through real quick. So fiduciary duty is sort of a enhanced duty, if you will. And it's a state law based concept. And not every state even has a cause of action for a breach of fiduciary duty, but you guys are going everywhere. So you have to be aware of it, even if the particular state that you reside in does not. It's utmost good faith and fair dealing. Here's an example. A claims handler sends you 25% of the income. You play late night card games at, one of the certifying organizations when we were all together and doing those sorts of things. So this person is generally your drinking buddy at all those conventions, and you're hired by the owner directly. Post-casualty, mind you. Say it's a sinking or a swamping scenario. You later run across the same boat in another claim, but you're not on for that particular adjuster. Just making a prophylactic appearance for the yard where the vessel happens to be. Do you call up your adjuster drinking buddy and say you might want to take a look at the wiring and see if it sank 2 years ago? What happens if you were on it for that adjuster in a second claim? Can you divulge what was in your initial report? Where does this fall in general knowledge versus breaching of fiduciary duty? Maybe the answer is you were conflicted in the first place and should never have taken the file. So again, what does it mean to breach the duty? I'm going to read it to you. Take a moment, read this slide. If we were in person, I'd ask everybody to look up at me so I know you're done. So I'm just going to give you a second. All right, so legal gobbledygook, but I just gave you the examples of what we're talking about here. Next, contract privity, breach of contract. This all comes back to how you wrote the contract in the first place. Specificity in the scope of what you're doing is important. Are you doing a rig survey as well? Or what are you saying about going to do on the rig? How far are you going? Does your mechanical include oil analysis or not? Are you always doing compression checks? What, if any, sort of rolling up your sleeves and getting out the wrenches are you going to do? Many people just won't do it and, third party it out. If you're going to be sort of the general contractor for different surveyors, specify that. People are now expecting, this wasn't true years ago, but people are now expecting that with thermal imaging everywhere. Everybody's got a thermal imager these days. It's not like the old days when I had to fly somebody from the West Coast to the East Coast when it was brand spanking new. Now you can go anywhere and get thermal imaging. Is it something that should be in every surveyor's bag? I argue that it takes so much training that it may not be appropriate in every surveyor's bag, but a plaintiff or a buyer who is disgruntled and wants to sue you, the surveyor, may take a different approach on that, given how prolific they've become. Sort of like a moisture meter these days has replaced the hammer. So in any event, when you do the actual drafting of your agreement, insurance policies are the example. You read an insurance policy, we've got you covered, except for the next 99 pages of exclusions. And I've read too many of them. That's exactly what they all do. So don't do that. I know that it's impossible. Nobody's going to actually sign that agreement, but have an agreement, one, in writing, which is amazing how many people don't do that. Two, put some specific scope in there. And three, actually have some details about what your agreement is all about. Lay out who can get it. Do you retain any interest in it? Is it your work product that you're licensing, for example, to a particular individual? Or is it their work product that they can do what they want with? So keep those things in mind, and you'll be fine on your contractual privity question. Now, here's the third item in our duty section, as they say. Warranty of workmanlike performance. Again, I'm not going to read it. Take a moment. This is the old 56 case. Read this for a moment. Okay, so we're going to discuss this a little bit here. So this is an implied warranty. This is part of your contract unless you specifically appropriately disclaim it, and then you may not be able to do that anyway. So it is implied. That is to say, if it's silent, this applies. This warranty parallels negligence, but it's not exactly the same. The owner of the vessel may be entitled to recover for the breach of the warranty, even if what you promised to do was performed without negligence. I'm going to back that up for a moment. The owner of the vessel may be able to recover for the breach of the warranty, even if the repair or the work that you were asked to perform was without negligence. So you can have one of those four elements of negligence missing, whether it's damages or causation or whatever the case may be, and ultimately still get hit with this warranty of workmanlike performance, which is implied in the maritime law. We have some cases back in 2006 which cover this topic that I just described to you. Anything else we need? I'm short on time here, so I'm trying to figure out where I can cut a little bit. Man, let's do a little more on warranty, and then we'll skip ahead to conclusion. So it doesn't impose strict liability on repairers and things like that and people who provide actual services. It does parallel, as I think we covered, there are more and more cases that are showing that, but the limited warranty is a cause of action that is acknowledged as based in neither negligence nor unseaworthiness. So we don't have to worry about those two topics, and you still could find yourself on the hook for warranty of workmanlike performance. Since it's not a strict, independent liability kind of thing, you still have to have the plaintiff showing and using its 51% burden that the conduct caused the injury that's being complained about. So that's really good for you guys, because you don't want a scenario where the burden shifts to you. Remember I said you don't want that ever? The plaintiff still has the burden, and that's been borne out in a couple of cases as well, wherein they discuss that very topic. Yeah, well, we covered causation enough. I want to make sure that we leave enough time here. We're at the 50-minute mark. So in leaving enough time for some questions, we'll do the quick summary of where we've just been. So we covered the up and coming areas, the areas of air quality, and also the emissions that went into effect. We covered this, what is your duty to your client? We have covered how to avoid some of the liability for negligence. And we've also talked about the contractual privity as well as the workmanlike performance issues that arise. So with no further ado, I would like to do a little shout out here for posterity's point. Jesse Schiffelow, who is a third-year law student and my law clerk currently, helped substantially. I dare say most of the presentation was prepared by her. And she is a second career, about to become a lawyer, any ocean, any tonnage captain. So that's, I want to shout out for posterity to Jesse for this presentation and thank her for working for me. And if you do get yourself into trouble, as Wavy Gravy said in the 1968 Woodstock thing, I like capitalism. Here's my contact information. So we'll leave that splash screen up for the purely capitalist purpose. Having said that, I have left 10 minutes, not quite 9 minutes for questions. And I will turn the mic back over to see if we have a triage of those.
Todd, thank you very much indeed. Fascinating, in-depth knowledge, totally relevant. I hope all surveyors have been sort of eating that all up. I have one comment really from Bill. It is my information and belief that under UK law, seaworthy is a legal term and can be determined by a court of law. A surveyor cannot determine if a vessel is seaworthy, as this includes the vessel and the operators. Would you like to comment on that, please?
Sure, I'd be happy to. I agree that it is really dangerous to be using the word seaworthy. I would attempt to avoid it. It has so many connotations, and there are so many things from air quality, as we've seen, right on through to the state of the mariners on the vessel. It is possible that a vessel is not seaworthy by virtue of the fact that it has perfectly operable radar, but nobody on board who's been trained to use it. That's been one of those cases as well. We had a casualty here on the Chesapeake Bay, and a death actually resulted. And it turns out that, unfortunately, radar was working great, but nobody on board was trained to use it. The vessel was not reasonably fit for its intended voyage. So I agree 100% that it is a good idea from plopping that label on. By talking about all of the surveyors who did, in fact, plop that label on, I did not mean to imply that it's something I think you should be doing. But as you can see, it's happened many, many times over the years, and a lot of the cases talk about this concept of seaworthiness anyway.
Thanks, Todd. Bob Snow would like to ask, are work orders that have been digitally signed legally binding?
Generally speaking, yes. The digital signature issue has been mulling since 1998. And there was even discussion back in 98 by some of the law professors about how to make sure that bills of lading became digitally signed and acceptable. There have been uniform laws that have been proposed. Many states have adopted laws in the individual states within the United States that accept them. Many countries as a whole have also. Where this question gets tricky is that as a regulatory matter, there are some sub-organizations within states that even accept, and I'm thinking of Maryland right now since I'm sitting in Maryland, for example, the Department of Natural Resources here, when it comes to a vessel title, will not accept the digital signature on a bill of sale or otherwise. They won't accept the printing of it, even if you print it in blue ink. You have to actually, I mean, I've seen them hold it up to see if the pen has made an impression. That's just silly, particularly because it happens all the time, everywhere. And the state itself has legislation that says the digital signatures are fine. So individual bureaucrats still flex their muscle from time to time. And in that context, you may find that there are holdouts. Generally speaking, yes, work orders that have been digitally signed are generally held to be legally binding.
Okay, I don't have any other questions. Anybody else with another couple of minutes with Todd? Anybody else want to ask anything else?
Well, I can't see your faces, but sometimes after I give these speeches, there's this this look somewhere between glazed over and panicked. And I hope I haven't panicked you in any way. I'm a realist, though, and I don't sugarcoat things. So I haven't given you any sugarcoating on this one.
Can I ask a question, Todd?
Please.
In the UK, we see exactly the same things over here. And Karen Brain is our version of you in the UK. She talks regularly to marine surveyors. And there is a Statute of Limitation Act in the UK. I can never remember if it's 6 or 7 years. And you would be, or we are amazed that sometimes it's 5 or 6 years later that someone brings a claim against a surveyor. I mean, it's not common, but it happens. And I just wondered what your experience is in the US with that.
Quite frequently, the statutes of limitations tend to be shorter. Generally speaking, if brought in under maritime law as opposed to a state law, there's this concept of laches, which is don't sit on your rights and just fail to pursue them, or you won't be permitted. Now, the reality is that typically a court will look to what would have been the applicable state statute of limitation and apply that as laches. Generally speaking, they are shorter here. One of the things that has shocked some people, though, is, do you remember that sometimes you'll sign a document and it'll have the word seal in parentheses near the signature line? Mm-hmm. That can pull your statute of limitations out to 12 years in many states. So one of the tricks is, if you really want somebody to stay on longer than the 3 or 4 years, you just put the seal word there in parentheses near their signature. That's now signed under seal, and in most states, you'll have a longer statute of limitations in the United States. So fortunately, shorter is better for surveyors, and you get that by operation of law, because even if sued in a maritime context, the laches concept looks to the state law. Does that satisfy your?
Yes, no, it's interesting. It's again just reminding people that it can be some time after an event happens that people can still come back and bite surveyors in the bottom. 2 other more just quick ones that have popped in. Mike would like to ask: was anyone at ABS or USCG held for anything regarding El Faro?
USCG wouldn't have been held by virtue of what was the Mel Brooks statement? The king always gets his share, and good to be the king, right? From history of the world. But because the USCG will not allow itself to be sued, the king doesn't let itself be sued. So that one I can say for sure is out the window. I am not able to tell you the answer off the top of my head about whether ABS has anything going after El Faro. I mean, they should, in my humble opinion, but that's just a humble opinion. From an ancillary perspective, I don't have any particular, I'm not involved in the case. So I can find out later for you if you'd like to fire me an email, but I don't know off the top of my head. And I see that, in fact, there's another question there. If I could jump ahead, I see it in the to everyone. And that is, what is the rule for document retention, surveyors, files, photos, etc.? Generally speaking, I always ask people for 7 years, even when we have a scenario where it's a 3 or 4 year statute of limitation. Even in that scenario, I like 7 years. So I advise my surveyor clients to keep stuff, but it's much easier to keep stuff now electronically than all of these folders, etc. So 7 years is something I recommend, even in the 3 to 4 year statute of limitations states in the United States.
Yeah, fantastic. Thank you very much, Todd. Look, thank you. Really appreciative to you for giving some time. Thanks also for allowing us to slightly flex the schedule today. And will you also send our thanks on to Jessie as well for her work, and wish her well in her career?
I certainly shall. And if anyone desires it later, we can talk about getting the deck here in a PDF format.
Fantastic.
Should that be desirable, you can click on some of those links
That'd be
to the
brilliant.
actual.
That'd
So
be great. Todd,
we'll
thank you very
circle
much.
back. Thank you all. Appreciate your attention.